and welcome to today's session on those pesky terms of use. Now, I've actually broken this program up to two parts because number one, I like to keep them really short. I like to keep them specific, these webinars. So today I thought we'd talk about what's important to users on websites because today really is a very, very important session if you actually access any of these social media sites. And obviously you do if you're on this call today. Next, I guess it's in 2 weeks, on the 29th, 2 weeks from today, we're going to talk more about what those of you who actually have created e-commerce websites, what you need to know about terms of use, because the laws have changed and they are changing dramatically. And especially if you are in California or you do business with anybody in California, you especially need to know what's going on in the law. So let's get started with today. And I want to make sure, let's see. Screen share. There you go. You should be able to see my screen. Oh, God. Damn it. Okay, so let's get started. And if you can't, I think you can see my screen. Let's see. Excellent. So I think you can see my screen share right now. Okay, so today again, we're going to talk about pesky terms of use with regard to what you as a user should be knowing. So most people, when they think of social media, they think of Twitter, LinkedIn, YouTube, Facebook, and Pinterest. That's pretty much it. Maybe they're throwing in Instagram today. But in fact, this is what the landscape looks like. It is so broad. There are so many social media sites that are constantly going up. It's just, I mean, it's unbelievable. It is unbelievable. So, what you need to know is that every single one of these sites, in fact, has a terms of use on it. So let's take a look. And what I want to do today is actually, excuse me, go through some of the terms of use. Okay, so a couple of things first, before we actually take a look at some of the terms of use, some of the things that you actually should know. Number one, terms of use are the same as terms of service and terms of conditions. Sometimes you'll see on a website, it'll say terms of conditions. Sometimes it'll say terms of use, but in all cases, the terms are exactly the same. It means that this is a relationship between you and the creator of the website, and you need to be paying attention. Something else you should know about terms of use, and for our purposes, I'm going to probably just use the term or the phrase terms of use to apply to terms of service and terms of conditions. The next thing that's really important for you to be aware of is that they do not exist to protect your rights. Now, I have to tell you, people are always calling me, excuse me, saying, Francine, I am so mad. How come? How come? How come? That's really, it's always starting that way. How come? How come? How come? Well, let me just tell you, it doesn't matter. It really doesn't matter because when they put those terms of use up on those websites, they exist for their protection, not for yours. One thing you also need to know about every single set of terms of use is that you give away a lot. You give away an awful lot. You give away a lot in terms of your rights, you give away a lot in terms of your content, but you should absolutely know that you give away a lot. They should be read and understood. Now, it's always an interesting thing to me that people will say, but I didn't read them or I don't read them. And I would imagine if I asked many of you right now, how many of you actually have read? Well, in fact, why don't you, let's take a look and do a little, let's see. Why don't you actually tell me, and on the chat, you can show me how many of you actually have read the terms of use that are on this website right now? And right now we're on Google+. How many of you? see. I'm seeing a lot of no's. Actually, I'm seeing an awful lot of no's. Well, that tells me something. So, whether or not you are reading them, whether or not you understand them, it is critical that you do read them. Because if you don't, you're going to still be held liable for what's on those terms. Why? Because courts are upholding them more and more. Every court in the United States, at least one of the major courts has upheld terms of use. And next in 2 weeks, when we talk about what the website owners need to know, you'll know why. You'll know the reasons that they do uphold them, and you'll know the reasons that the courts are not upholding them. But the bottom line is whether you read them or you don't, you're going to be held liable for what's in them. They create binding and enforceable agreements, which is why it is so important for you to read what's in them. Because the truth is, when you click that I accept, you are technically saying, I am entering into this relationship with you. I accept means that you agree to be bound. Some of the things that you agree to, whether you know it or not, in those terms of use, are you agree to arbitration. And arbitration may or may not be a bad thing for you, but it's almost always a good thing for the person who has included them. You also, whether you know it or not, agree to jurisdiction. So let's say, for example, you are someone in California, but let's say that the terms of use say that any dispute will be resolved in New York or in Florida or in Maine. That means you will have to go to that other jurisdiction in the event you file a suit. Excuse me, you'll have to go to that jurisdiction and defend yourself, or you'll have to hire a lawyer in that state to defend yourself. So, it's so important. And let me say this, people will always say to me, but Francine, I can't do anything about it anyway. And perhaps you can't, but at least you should know what you're getting into because you always have a choice. And that was what one of the courts recently came down and said when someone had complained about YouTube, saying YouTube was, too big and it was just a little bit, just a little bitty person up against YouTube. They had no chance. And the court said, wait a second, you always have a chance to use another video sharing site. And you could also put videos on your own website. So don't come back to us and say you do not have a choice. So for that reason, guys, I say to you, you need to know what's in those terms of use. So here are some examples. And I find these all so very interesting. And I'm not sure how many of you actually know what these are saying, but here's an example. And every single one of the terms, and I've taken just a few snippets from some of the primary ones like Twitter, Facebook, Pinterest, Instagram, and YouTube. So I've taken a couple of uh, a little bit of the text, some of the terms of use, but I must tell you that they're all the same. Every single one of them has something very, very similar to what I'm going to show you. So here is what Twitter says and all of the others, and they almost always start out their terms by saying something to this effect. Your access to and use of Twitter services is conditioned on your acceptance and compliance with these terms. So that's the first thing they say. They say that if you continue to use their website, then you are going to be required, or technically you accept their terms. That's what they're saying. You use our site, technically you are saying you accept the terms. And then they continue to say by accessing or using the services, you agree to be bound by these terms. So once again, this is only reiterating what I said before, that you are entering into a binding agreement with, excuse me, it's allergy time. You are entering into a binding agreement with Twitter or Facebook or Google Plus or YouTube or any other website that you say I agree to. They're all saying that you basically are agreeing to their terms and you are entering into a contract. It also goes on to say you may use the services only if you can form a binding contract. So there's that language. I mean, they specifically say that this is a contract. You may use the services only if you can form a binding contract with Twitter and are not a person barred from receiving services under the laws of the United States and other applicable jurisdictions. So again, whether you read them or not, this is what it says, and this is what you are agreeing to. Okay. The next, and they all say this as well, so you definitely should be aware of this. So here, for example, and this is a snippet from Twitter, but this is exactly what Facebook says. Some form of this, and in fact, some of them are even broader, as I will show you. So here, Twitter's terms of service say your rights. You retain, and this is what everyone loves. This is what everyone loves. Everyone jumps on this and says, Twitter says I own my own content. Facebook says I own my own content. Instagram says I own my own content. But no one wants to read the rest of that sentence. So here is the rest of the story. Twitter says you retain your rights to any content you submit, post, or display, or through the service. Okay, again, that's what we like. We want to see that. But then they also go on to say, by submitting, posting, or displaying content on or through the services, you grant us, and this is the most important section here. You grant us a worldwide, non-exclusive, royalty-free license with the right to sub-license, to use, to copy, to reproduce, to process, to adapt, to modify, to publish, transmit, display, and distribute such content in any and all media or distribution methods now known or later developed. Now, if you've never read that before, let me just tell you a little about what that means. And in fact, it's pretty explanatory. It says by you posting on this site, whichever site it is, in this case, it happens to be Twitter, but this is what Facebook says, this is what Instagram says, this is what they all say, this is what Pinterest says, Google Plus, every single one of them says the same thing. Once you post, once you display, once you put your content on our site, you in fact are giving us the right to do anything and everything we want to do with your content. Yes, you own it, but you give us the right to do anything and everything, including, and here it says, sub license. A sub license means they have the right to also allow other people to use your content as well. They also have the right to, again, reproduce, process, adapt. So they can make changes to it. They can adapt it to a certain way. They can modify it. They can do anything they want. Now, I stress this piece here because everyone that complains that someone took their content off of Pinterest or off of Twitter or off of Facebook, if they're on Facebook or Twitter or Pinterest or Instagram, you have already given that site the right to allow someone else to use your work. Further, Twitter's terms of use say we encourage and permit broad reuse of their content. They actually come right out and tell you we encourage people to broadly reuse the content, which means they can retweet it, share it with someone else. They can do all kinds of things because you have given Twitter, Facebook, Instagram, all of these sites the right to do that. It also, again, says we may modify or adapt your content in order to transmit, display, or distribute it over computer networks and various media and make changes to your content as necessary. Again, all I'm doing today, we've only got about 30 minutes, so all I'm doing is really just sharing with you what these terms of use say because in all likelihood, you haven't read them. So let's take a look at some more. Facebook's terms of use, sharing your content and information. Again, pretty much the same thing. They say you own all of the content and information you post. That piece has become the downfall of most users because, again, they only focus on you own all of your content and they, in fact, think that means something here. But I'll tell you, it doesn't mean a whole lot because even though you own it, you've still given pretty much everyone else the right to use your work. Now, there have clearly been some cases over the last few years where on specific little issues, people have won. But I will tell you, I'm still waiting to see this phrase here, this section here, truly litigated, because I think you may find, and we don't know yet what's going to happen, but I think you may find that the courts just may uphold a lot of this because the terms clearly say you give us the right, subject to your privacy applications. And that's an important piece too, because a lot of people haven't even changed or modified their privacy settings. So if, I would imagine if you go into your own settings today, unless you've specifically said they're going to be private, they're probably open to the public, or they're open to friends of your friends, which could lead to anything. That's pretty much like being open to the public. So here it says for content that is covered by intellectual property rights like photos and videos, this is Facebook, you specifically give us the following permission subject to your privacy and application settings. Again, you grant us a non-exclusive, which means we're not the only ones. Transferable, you give us the right to transfer, sub-license, that means pass it on to someone else. Royalty free, that means you don't get paid if they decide to transfer or modify or do whatever it is they will do with your content. Worldwide license, that means they can use this license anywhere in the world, not just in your state, not just in your country, but everywhere. To use any IP content that you post in connection with Facebook. So anything you put up on Facebook, anything, photographs, baby pictures, music. If you write your own original content and you do not register it with the U.S. Copyright Office to make sure there's a registration in place, then you might be in trouble. You just might be in trouble. So again, I'm just going over the terms today, just wanting you to know what's in fact in these terms that you have agreed to. And again, I stress, if you are on this site today and you have posted anything on Google Plus or Facebook or Twitter, if you've ever posted on Instagram or Pinterest, you have agreed to something quite similar to this. Facebook also says under the title Public Access, when you publish content or information, again, they're clearly telling you that when you publish content or information, and I've tried to take quotes so the language is as specific and as verbatim as possible from the terms. When you publish content or information using the public setting, it means that you are allowing everyone, including people off of Facebook, to access and use that information. Is that really understood? Again, so if you have not changed your privacy settings and you have, unless they're private, that means you've either had everyone be able to access them or friends of your friends. So if they're friends of your friends, again, if they happen to have public access, then that means your content's going out there as well, which is fine if that's what you want. Again, this is just about providing you with information. You should know what you're getting into. Something else Facebook says, which is very interesting, most people never read this section. Facebook users provide their real names and information. It's telling you that this is what you need to do. And I had a client recently call me up who wanted to sue Facebook, which is just the craziest thing because, quite honestly, unless you have a really, really, really solid claim with regard to these terms and with regard to what you're doing, it's going to be hard to overcome and it's going to be a very expensive lawsuit for you because you will have to pay. Here is one of the ways that Facebook protects itself, where they can get rid of you. They can disable, disactivate your account if you do a number of things. There were too many things to put here, but I pulled out a few of them. You need to read their terms of use. Here are just a few of the things. Facebook says here are the commitments that you make. You will not provide any false personal information on Facebook or create an account for anyone other than yourself without permission. So what that's saying is if you use a fake name or if you create an account for someone else, you are doing something against the terms of use on Facebook. You are violating their terms and they can deactivate, disable your account. You will not create more than one personal account. So if you've created or if you've made an attempt to create 2 or 3 personal accounts, Facebook can shut you down. And then for you to come back crying and say, but look at what they did, it clearly says right here, you will not create more than one personal account. That is a commitment you make in this contract that you sign when you click I accept. Something else, you will not use your personal timeline primarily for your own commercial gain and will use a Facebook fan page for such purposes. Now, I had another client recently who also had a problem because Facebook disabled their account. And they were really, really mad. They said, I've been using this account selling my product, and all of a sudden Facebook came and shut me down. Well, hello, the reason they shut you down is because you violated their terms, because you agreed when you clicked accept that you would not use your personal timeline for commercial gain. You could have started a fan page, which is for that purpose, it's a business page, but you chose to advertise all of your products and services and everything on your personal page. Facebook says no. You did, you're down. You will not use Facebook if you are a convicted sex offender. That is just the way it is. You will keep your contact information accurate and updated. You will not share your password in the case of developers, your secret key. You will not let anyone else access your account. Now, this has become a very uh, contentious area uh, because this also could apply to someone who dies, and then how would their estate gain access to their account? It has not changed yet. There's a law that potentially is being considered, but until it does, until the state where you live actually makes a law that says otherwise, if you share your password with someone else and Facebook finds out, they could cancel your account. So, again, this is just a few of the things. There are so many more. You need to read the terms of use. LinkedIn's user agreement, very similar, and it welcomes you, thanks you for using LinkedIn, very polite, and all of its component parts, SlideShare, Pulse, and other LinkedIn services. It says when you use our services, you are agreeing to our terms. Once again, it clearly says you are entering into a legally binding relationship. You are entering into a contract. LinkedIn also goes on to say under the membership section, it's 2.2, it says you'll keep your password secret. You will not share an account with anyone else and will follow the rules of the law. Again, they're all saying something very, very similar. If these things are all new to you, that just goes to show you have not read those terms. And again, I stress, whether you read them or not, whether you understand them or not, you will be held liable for what they say. LinkedIn continues to say your license under your license section, which is 3.1, it says as between you and LinkedIn, you own the content and information. Again, this is a repeat of what we've gone over. They all say this. Sometimes people think, oh, LinkedIn is so much better. It's going to do a better job. It's not going to take all my. LinkedIn says exactly the same thing. As between you and LinkedIn, you own the content and information that you share. But it also says you are granting LinkedIn the following non-exclusive license: a worldwide, transferable, and sub-licensable right to use, copy, modify, distribute, publish, and process information and content that you provide through its services. You are, in fact, allowing LinkedIn, Facebook, all of these venues to do the same thing you can do with your copyrightable work. So if the work is yours and you have a copyright in it, you have, by clicking I accept, given all of these venues the right to use your content in the same exact way that you can. Again, that might not be a problem, and that may be something that you really want, which is great, but just know that's what you've done. That's all. Just be aware that this, in fact, has what the right that you've given up. Instagram again says the same thing. By accessing or using the Instagram website, you agree to be bound by these terms. It says these terms affect your legal rights and obligations. If you do not agree to be bound by all these terms, do not access the service. Again, I'm repeating certain items here because they are so critical for you to understand that, number one, this is a contract. It's not just some simple, or some words that you feel are too complicated and too long that are just tacked onto this website. This is a contract. Pinterest, again, very similar. Pinterest allows you to post your content, including your photos, and they encourage you to do it. And it says you retain all of your rights and you're solely responsible for the content that you post. You retain all of your rights and you grant Pinterest and its users. Now, Pinterest went even a little further, which is interesting. Pinterest says not only do you grant us a license, but they went and specifically said, and you grant our users a non exclusive, royalty free. That means if somebody reposts, repins, reshares your content, you don't get paid for it. And they, in fact, can pass it on to someone else. A non exclusive, royalty free, transferable, sub licensable, worldwide license to use, store, they've added something else, display, reproduce, repin, modify, which means they can change it, create derivative works, which really, I mean, they've gone to the next level. So that means that you're giving Pinterest users the right to take your work and put it in something else. So if someone, let's say you put up a photograph and the photograph's really wonderful and it's a photograph that you actually normally would get paid for, you are giving, once you post it on Pinterest, you're giving other users the right to now take it. They can take your photograph and they can also put it into a collage and even sell it themselves if they want, or they can make an attempt because nothing in here says they can't sell it. So again, it's just about being mindful of what you're doing. So you are free to pin and put up anything you want. Just know that once you do that, you have given other people the right to do the same thing that you can do. YouTube says you agree that your use of our services shall be at your sole risk. They come right out and tell you that too, that by using their service, you are doing this at your own risk, at your own peril. You step into the venue, if you will, to the lion's den. YouTube also says YouTube reserves the right to decide. Now, this is an interesting one also. YouTube reserves the right to decide whether content violates these terms of use for reasons other than copyright infringement, such as, but not limited to, pornography, obscenity, or excessive length. YouTube may at any time, without prior notice and in its sole discretion, remove such content and or terminate a user's account for submitting such material in violation of the terms of service. So really what this is saying is, let's say you put up some content, and actually I had someone a couple of months back who contacted me because she was very angry. She had what even I considered to be pretty much porn. And she got very upset because YouTube terminated her account. They totally disabled it. They said she cannot use their services anymore, period, because they had actually given her a couple of chances. They had forewarned her. She continued to use it. So she continued to use it. And Facebook just said, YouTube just said, okay, we cancel the account completely. So they get to decide what's inappropriate content, not you. It says YouTube reserves the right to decide whether the content is in violation of its terms of use beyond copyright infringement. So again, if you want to use their service, you need to use it in the way that they want you to. So I think I'd like to end with some takeaways. And really, it's reiterating everything I've already stated, but I want to stress it again because I think this information is so critical for you as a user. Number one, it is key. I mean, it is key for you to understand that these agreements, these terms of use are enforceable, valid contracts. That's what they are. They are contracts between you, the user, and the website owner. They are enforceable, and courts are enforcing them more and more. Secondly, you really need to read them. I get that they're long. I get that they're complicated. Although I will say, as I was doing some recent research, some of the sites like Pinterest and Instagram, they're making them a little easier and a little more user friendly. In fact, they'll have their terms on one side, and then in a little box, they have like a layperson's interpretation of what those terms mean. So, you know what? Read them. That's what I'm going to say. Read the terms of use. And the last thing is whether you like it or not, whether you like those terms, whether you think they're fair, whether you think they're filled with legalese, whether you just think, you don't care about them, you're not going to read them anyway. I get it, but whether you read them or you don't, if you accept them, once you click I accept or I agree, you become bound by those terms. It's really that simple. Okay, that's it for today's webinar. Oh my God, 10:30 on the money. I'm attorney Francine Ward. Again, trying my best to provide you with some useful content that you can use right now, making you more aware of what the law is. Join us in 2 weeks on April 29th, same time, 10 a.m. Pacific Standard Time, for the next uh, webinar in this particular series on terms of use, where we'll talk about what those of you that actually have e-commerce sites, websites where you are actually selling product or providing, in fact, selling product, but not just selling product. If you are requesting personal identifiable information from any of your users, you definitely need to know what we're going to talk about in 2 weeks, what your terms of use need to include, and how they need to be placed on your website. Okay, that's it for now. I'm attorney Francine Ward. Take good care. Bye bye.